Good afternoon, Chief Justice.
Are you well?
I'm very well, thank you, and I trust you are too.
I am, thank you. Are you relaxed or should I help you?
I'm as relaxed as I can be under the circumstances.
Okay. Why did you pursue PhD after becoming a judge?
Well, I graduated with my PhD the same time that I was appointed as a judge. I'd in fact done all the work and submitted before I was appointed.
Yes. And have you been lecturing part-time or not?
I'm presently an honorary professor at Rhodes, and I'm required to give a few lectures every year.
Yes.
So I give a course of lectures over a week during one of the recesses.
Just at this preliminary stage, I was called by a colleague, and I'm asking because I don't know the difference. He was saying that he thought it was necessary for me to know that he was appointed a professor extraordinaire. Are you also a professor extraordinaire, or is that a different category?
No, I think I'm just an ordinary honorary professor.
Also, extraordinaire is a higher level.
I think different universities have different terminology for essentially honorary professorships.
I see.
That would be my guess.
I see. And for how many years have you been a judge of the High Court now?
I was appointed in June 2003, so it's about 16 years.
About 16 years.
Yes.
And for how many terms did you act in the SCA?
I acted for
I thought I had made
probably about 12 terms now. I'm not 100% sure, but in 2011 I acted for the whole year and into 2012. Later in 2012 I acted again from September onwards to the end of May.
Yes.
I acted for a term in 2016 and for 4 terms in 2017 through to 2018.
Yes. Tell us why you should be recommended for appointment out of this group of how many? Are they 9? Are you all together 9?
Yes.
Yeah. Why should you be one of the 5? In your own words, just take your time.
Well, I'm now an experienced judge. As I've said, I've been a judge for nearly 16 years. I believe I've got a good track record as a judge, so that my reported judgments will attest. I've acted in the SCA on a number of occasions, as I've indicated, and I would like to think that I did a good job there. And so I would like to think that I'm suitably qualified to be appointed.
On the assumption that you're all suitably qualified to be appointed, what extra would you say we need to pay particular attention to?
Well, I suppose what I do have is expertise in administrative law. From my days in academia, from my days in practice, and on the bench. And my doctoral thesis is in administrative law. And I think that's become an increasingly important topic or subject in our courts. So much so that over the last few years I've been asked to lecture on it in courses for aspiring judges. It's the one substantive bit of law that is dealt with in that course. And I think it's because you need, certainly on the High Court bench, to know your way around administrative law to be able to do motion court.
Thank you. President Meyer.
Thank you, Chief Justice. Good afternoon, Judge Plasket.
Good afternoon, Judge Meyer.
I don't really have any questions for you, just one comment, rather. You earned yourself a reputation as a fearless fighter for the disadvantaged, and you waged a long battle with the Eastern Cape government to ensure that it honored its constitutional obligation to provide social welfare assistance to those who need it. And that earned you, some ire from the powers that be at the time. You were seen as the anti-government judge because of that.
Yes, I'd like to think that the work I did was worthwhile and I certainly believe that it was the right thing to do. Old people entitled to disability grants, people entitled to maintenance grants, as they were once known, child care grants, and so on, tend to be the most vulnerable in our society and aren't organized politically. And I thought it was particularly important to take up that cause, which when I was at the Legal Resources Centre. And I think we played some role in the system being fixed. And I think it's greatly improved now. We certainly don't have the type of crisis that we did back then in the 1990s.
And I assume that you thoroughly enjoy your time at the SCA, hence you have kept coming back whenever you're invited all these years.
Yes, I find the work very interesting, very stimulating. It's varied, and you get work in the SCA that you wouldn't get necessarily in the Eastern Cape. Patent work, customs and excise work. I've even been involved in tax cases, which I'd never dealt with before. I enjoy the court, and I enjoy working in a collective, in a team. And I think that the SCA gives you the perfect opportunity to do that.
Thank you, Judge Plasket. Thank you, sir.
Thank you, President. Commissioner Norman.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon.
Thank you. I see you've written about 60 articles ranging between human rights, administrative law. Those are all published articles.
Yes.
Yes. There is the one that really fascinated me, the one that you highlighted in paragraph 6, the Eastern Cape Bench, Civil Liberties, and the 1985-1986 state of emergency. But there's a paragraph that I just want you to talk to, where you had done a calculation of the number of people that were being detained during that period, and where you were suggesting that between, I think, August 1985 to February 1986, there were about 3 people that were killed each day. What is it that prompted you to link these atrocities to the Eastern Cape Bench?
Well, I think I was writing about the broader environment then.
Yes.
of state lawlessness, essentially, where people were looking to the courts for protection from the police. Yes. And from the defense force. So what was happening was people were being detained, people were being killed. At the time, I was living in East London and teaching at the Rhodes campus there, which is now the Fort Hare campus. And I was involved in an organization that provided legal and medical assistance to victims of police shootings and army shootings. So it was in the forefront of my mind, I suppose. Yes. And what I think I was saying in that article is that people were looking to the courts for protection and not always getting it.
Yes. Thank you. Thank you, Chief Justice. Thank you.
Thank you, Commissioner Norman. Commissioner Nokesi.
Thank you, Chief Justice. Justice Plasket. You were once a secretary of Nadel in the Johannesburg branch, way back 1989.
Yes.
How would you use your experience as a human rights activist back then, where if you are appointed to the SCA in view of some tensions which would be arising from some prejudices that are arising from that court, how would you assist in trying to ensure that there's a unity in diversity in that court?
Yes. Well, you know, I think one of the important aspects of NADEL as an organization in the late 1980s and 1990s, when I was involved in it, was the fact that it brought together lawyers with a common vision for the future across racial lines. It was a non-racial organization that was aimed at achieving the type of society that our Constitution envisages. And I think that experience assists one, even now, to work towards a non-racial society. I think that is an important goal, and it's an important value of our Constitution.
My last question is, I mean, through your judgments, the articles that you have written, you show a strong commitment on the human rights and the realization of human rights. Your judgment are very quite explicit on that in the articles. How through law we can ensure realization of economic rights? How through jurisprudence we can tap into those areas that there is a fair, at least access to the economy in this country of all people, by all people?
Well, I think the question you pose is a very difficult one, but its starting point is perhaps an obvious one, and that is our Constitution is a transformative document. It doesn't just transform the organs of government. It aims at transforming our society and undoing the effects of apartheid. And that involves positive enforcement of rights, not simply waiting for them to be infringed and stopping the infringement. It involves the positive attainment, particularly of socio-economic rights. And that's the difficult part, because it raises for the judiciary, I suppose, in the first instance, the separation of powers. In requiring organs of state to fulfill socio-economic rights, one has to tread quite carefully, because the issues are very complex. You're dealing with budgetary constraints. You're often dealing with complicated planning issues and so on. But in the Blue Moonlight judgment, which I co-authored with NAFSA JA a number of years ago, we said the attainment of socio-economic rights is about the art of the possible. And one needs innovative ways of getting there. Primarily, the responsibility rests on the legislature and the executive, but the judiciary has an important role to play as well, because the legislature and the judiciary have to attain those rights through reasonable legislative and other measures, and that's where the judges come in. And there's, I think, some very impressive socio-economic rights jurisprudence that have come from our top courts, particularly the Constitutional Court.
Thank you. Just on Blue Moonlight and and here I include the Constitutional Court judgment, hasn't it created more problems than bring about a solution, though? I know of a current instance where somebody bought property, people came in illegally, others left and others came in. They connect electricity, they connect water, the bill is running. And the fellow is trying to litigate. Courts have got rules that you have to wait long before the matter is heard. A fellow can't use his building.
Yes,
And you're stuck there forever. And they know, they say, no, blue moonlight. They even know the case. And you'll suffer almost forever. What is it that needs to be done to make sure that people who really don't have accommodation are not thrown out with the brutality and heartlessness that accompanied those evictions during the apartheid era without ruining, or not ruining, but without undermining in a very serious way the possibility of owners ever enjoying their right of ownership? In other words, what is it that needs to be done to arrest the abuse? Because in several instances, it's downright abuse. People hijack buildings not because they didn't have accommodation. They have it. They just want to hijack.
yes. I think you, Chief Justice, you raised some very important and serious issues with these big inner city cases, where you're dealing with large numbers of people, buildings that are degrading by the day, becoming unsafe, people who need somewhere to stay. Leave aside the hijackers of buildings with bad, who act in bad faith. But for me, and I think this was what we were really trying to say in Blue Moonlight, is that municipalities have an obligation to provide emergency temporary accommodation in those instances, so that you can strike the balance and not have the vicious ejections of the past on the one hand, and still have a reasonable prospect of an owner being able to use his or her building in a reasonable period of time.
Well, just to give you a Blue Moonlight, when last was it decided by the Constitutional Court, those occupants are still temporary occupants over 5 years later, and it looks irresolvable. What is it that needs to be done to balance as sensitively as one needs to the interests of illegal occupants and the interest of owners?
I'm not sure what the answer is, because I suspect it's an intractable answer that relates to resources on the part of municipalities and access to land and various other things. But it's a problem that you see replicated across the country, I think, certainly in the major
It is.
cities.
One man bought a building with his pensions. He never got to occupy it. He never got to use it. And he's doomed. Which caused me to ponder, and wonder just how practical are we as judges in dealing with real life issues? Do we venture into the deep future, or is it more a question of the law says, therefore, 1 + 1, boom, that's it?
Well, I think we have to be careful about being too timid, but at the same time, there are limits to what we can do and what the law can achieve. We are but one arm of government. There are two other arms of government that also have responsibilities, and sometimes I think the law can't supply the answer.
Now, I'm speaking only for our side, for our arm. Not minding whether you'll be praised or condemned, because it does play a factor, I've come to realize. If you know that favorable articles are likely to be written, either by members of academia or journalists, I heard from some colleagues abroad that they tend to think twice before they take a position that is unlikely to be celebrated. So you find yourself being led by journalists and the academia rather than doing that which is in reality the right thing to do. I just wanted to find out just how much effort do you think we make as judges? Not to look like we live in ivory towers, flowing from the kind of decisions that we take. How real, how pragmatic are we in our approach?
Yes. I think generally speaking, we do a fairly good job, if I may say so. And our feet are pretty firmly on the ground, if I can speak for about the judiciary generally. But here we're talking about really difficult issues and intractable issues, and where often you're going into uncharted territory, and there I think we have to be careful, and there is the danger of pie in the sky judgments.
Sure. And we're only human, and we
Yes.
will sometimes get it right and at times get it completely wrong.
But luckily there's a system of appeals which can hopefully correct those problems.
Comprising human beings still.
Yes.
Yes. Okay. Commissioner Nyambi, was your hand up, Minister? Okay. Oh, the Minister says he wants to follow up. I don't know if your question also will be some kind of a follow-up, in which event you must go first.
No, it's not a follow-up.
Oh, okay. Thank you, Commissioner. Minister?
Yes, I really feel I should make a follow-up to the CJs. I mean, we've done an audit through a study of the socioeconomic jurisprudence that has evolved over the past 2 decades, and have submitted it to each government department to reflect on it and its implications for itself, so that as government we can have a collective approach going forward to addressing the issue of honoring socioeconomic rights. But that's just in passing. The concern that I really have, which is more or less along the same lines that the CJ has, is that my understanding of the Constitution's approach to socioeconomic rights, it generally uses the concept progressive realization.
Yes.
And my understanding of the import of that is in recognition that we are not a developed society, we are a developing society, and that it will take time for us to reach a stage of socioeconomic equity across the board. And of course, as if that's not enough, we also have to carry the burden of the influx of those that find life difficult elsewhere, especially on the continent, coming over onto our, into our country and so on. Isn't this something that the judiciary should be considering, given the fact that the principle is already infused into the Bill of Rights itself? It seems as if, to me, the approach to socioeconomic rights, at least at some point of the evolution of our jurisprudence, has been one which is a little bit too radical and too ahead of the reality of the situation that actually pertains, that should be taking account of also the resource constraints of the state.
Yes, I think the idea of reasonableness on the one hand and progressive realization on the other are the keys to it all. and because they speak to the programmatic nature of socioeconomic rights. It's impossible, the old example, to provide everyone with a house tomorrow. One has to have the resources and have the planning and then start rolling it out. And it's even so, it is a daunting task. And it requires a state that is functioning optimally all the time, I suppose. So I think judges have to be mindful of that. And that requires the wisdom to recognize, I suppose, where your role ends as a judge, the separation of powers issue. Because you can't place obligations on an organ of state that doesn't have the resources to deliver. It's unfair and it's unreasonable.
But isn't judgments like this actually having the exact effect? And secondly, and that's my last point about this, the founding provisions talk about the rule of law as paramount. Isn't this sort of thing encouraging a culture of anarchy and disregard for the rule of law? That people can use self-help, and when somebody else asserts the rule of law, the courts come to their avail and therefore entrench a culture of anarchy which is inimical, in my view, to the notion of rule of law.
Well, I think if we go to the Blue Moonlight judgment, the nub of it was that we said that the city of Johannesburg had an obligation to provide temporary accommodation for the people who were resident in that building. So the idea was to balance out the rights of the illegal occupants of the building on the one hand and the owner of the building on the other. That was certainly our intention. And we recognized that the municipality also had the budget on the evidence to be able to provide that temporary accommodation. I understand from a question of the Chief Justices earlier that they are still in that temporary accommodation. Well, that's something we certainly didn't foresee. The second aspect of your question, Minister, relates to the legislation that we are required to, or that we implement, and that is the PI Act, which aims at achieving that balance and to ensuring that people aren't unjustly and arbitrarily evicted, and that all factors, relevant factors, are taken into account before an eviction order is made, so that they aren't rendered homeless, that there's some safety net, if you like. And on the other side, the idea is to ensure that the owner can have the right to his or her property. Generally speaking, I would suggest that legislation works fairly well, fairly effectively, and fairly fairly. But these inner city mass evictions are of a different order altogether, and far more complex and complicated than anything else that I've seen, certainly.
My last follow-up, if I'm allowed, Chief Justice. You see, earlier on we're talking about the Informal Land Rights Act and how balancing between those rights and, mineral rights could be achieved in the context of two competing statutes. But it seems to me here that we're talking of something completely different. People who have acquired occupation through unlawful means. And we're seeking to protect that unlawfulness. I'm not sure whether the legislation envisaged to entrench rights in circumstances such as arise there where the occupation in the first place was an outright violation of the law. I seem to see some distinction between the two scenarios. And if that is so, my concern is how the court then finds it easy to actually then entrench rights acquired through unlawful means.
I don't think that that's the intention. What the Act does is regulate the eviction of unlawful occupiers. So it doesn't say that unlawful occupiers or allow for unlawful occupiers to remain in occupation. It deals with the timing of the eviction, but once a person is an unlawful occupier, an eviction order can be made, but only after all relevant circumstances are taken into account, which really, I suppose, comes back to the timing. So children aren't unduly prejudiced, placed at risk. Old people aren't placed at risk, so that you have time to find, a person has time to find alternative accommodation. That's certainly my understanding of what the intention of the PI Act is.
I think part of the challenge which practice has revealed is that it's very difficult to determine how temporary is. We grappled with that question and we realized that nobody knows how temporary was intended to be.
Yes.
And two, the quality of the presentation, the truth be told, on the side of the state has been particularly frustrating. You don't get enough information in relation to determining or finding out where these people have been. Because some of them might still have homes, but have chosen to go and be there because it's easier to go there. And three, just to help the court arrive at a decision that adequately accommodates both sides. Most of the time, I know it's some kind of a generalization, but most of the time, you'll find that the state side of the case is not particularly helpful. It's almost as if the attitude is, what can they do? Let's just send whoever we can send with whatever information. And the other side tends to be thorough and more prepared, with the result that you find yourself warming up to a more persuasive presentation than the one that is presented anyhow. And that seems to have contributed to some of the challenges that we could not have anticipated.
Yes.
Yes.
Yes, I think that's absolutely correct.
Yes. Commissioner Nyambi?
Thanks, CJ. Afternoon, Judge.
Good afternoon.
Your numerous writing, whether they are journals or books, set you apart as not being shy to express your views, which you gain through studies and experience as a law practitioner, of which is a good thing. Do you mind sharing with the panel what your views on the South African land question are?
Well, the Section 25 of the Constitution certainly speaks to land reform and land redistribution. I would prefer not to express a view on the question of expropriation without compensation, particularly because I haven't seen the legislation or the draft legislation. And I would only want to do that once I've seen it.
Maybe you can share with us your interpretation of that Section 25.
Well, I want to get to the heart of it. sub 2 talks about that property may be expropriated only in terms of law of general application for public purpose or in the public interest, subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. That's the current situation in terms of the Expropriation Act. And then 3 makes provision for the amount of compensation being influenced by various aspects. And one of the arguments that I've picked up is that if one looks at things like the current use of the property, the history of the acquisition of the property, and so on, one may get to the situation where the compensation is 0. And in that instance, the Constitution, as it presently stands, could even contemplate expropriation without compensation. I would imagine, to be frank, the situations where that will happen will not be that common, because in most instances land will have a value that you can ascertain, and it won't be 0. But moving on, the para 5 and 6 and 7 make provision expressly for land reform. And this is, again, the point I was making earlier about the Constitution placing positive obligations to undo the inequalities and the injustices of the past. So the state must take reasonable and other measures to foster conditions which enable citizens to gain access to land on an equitable basis. Tenure reform, a person or community dispossessed of property after 19 June 1913 is entitled to restitution. And we know that that restitution process has been in place and running for a long time now, since I think 98. A lot of the criticism has been that it hasn't been effected efficiently. And the one argument is that that's no reason to amend the Constitution. I put out those views, and I would rather not give a definitive position on all of that. But it seems to me that the Constitution makes provision for all that is required.
Thank you, Judge. Thank you, CJ.
Thank you very much, Commissioner Nyambi. Commissioner Masuku.
Thank you, Chief Justice. Good afternoon, Justice Plasket.
Good afternoon.
I am intrigued by your interest in the Promotion of Equality and Prevention of Unfair Discrimination Act. What do you think can be done to make sure that that act comes alive? Because it seems to me that most of the structural problems that promote discrimination could be resolved, could find some resolution through that system created under the Act. But my sense is that the courts created under the Act are not really being utilized well enough.
Yes.
But the second question I have is, do you see a relationship between that Act and the Promotion of Administrative Justice Act? Because I did a case some time ago, which ended up in the SCA. My cause of action was found in the Equality Act, but I raised grounds of review that that could be found in Paja, and the court said no, you can't use one in order to promote the other. But I see a relationship between the two, that it ought to be permissible in order to promote equality and prevent unfair discrimination, to actually take administrative decisions or actions that build up that kind of situation that the Equality Act seeks to promote. So is there a relationship that you would see, you know, between the two acts? And if you are appointed to the Supreme Court of Appeal and a case like that comes up, would you perhaps consider finding that relationship?
Well, it's a very interesting issue. I know there are cases in which equality issues have been dealt with in terms of the review of an administrative decision. I'm also aware of that, of this idea of separating out the two jurisdictions. But classically, administrative power is used to discriminate. I mean, under the apartheid system, most discrimination was effected that way. Parliament may have mandated it, but it was administrative officials who did the actual on-the-ground discrimination. So it's not and our common law recognized that inequality was a form of, or unequal treatment was a form of unreasonableness in administrative law. I think the issue that you raised arises because of the constitutional context, where the Constitution has said the equality right must be given effect to through national legislation, the Equality Act. The administrative justice right must be given effect to through national legislation, the PAJA. And I think the courts have said, well, you must go with one or the other. If you raise an equality challenge, you must do it through the Equality Act. If you raise a administrative law challenge, it has to be done through PAJA. And it seems to be that if an equality challenge is raised, PAJA isn't appropriate. But having said that, there are earlier cases that go the other way. I suppose but they didn't really consider that. They pre the legislation, mainly. It's one of those difficult jurisdictional issues, I think.
Thank you, Justice. Thank you, Chief Justice.
Thank you very much, Commissioner Masuku. Commissioner Singh? Thank you. Commissioner Mpofu?
Thank you. Good afternoon, Justice.
Good afternoon.
Thank you. Good to see you.
Yes, it's been a long time.
Been a long, long time, yes. Now, thanks. I was going to ask you one question, but somebody, I think Commissioner Nyambi has provoked a second one, yeah. I think that you have, well, I have an interest in administrative law for a long time. It was taught to me by Etienne Murenik, one of the masters. But there are two issues that I want to ask. One is about the issue that was asked about land expropriation without compensation. And I would like you to assist me here. How is it possible? There are eminent lawyers, I'm told, who say that the current section allows for, the current section 25 allows for land expropriation without compensation. Now, for a lawyer, a section that says property may be expropriated only in terms of a law of general application makes it very clear, subject to compensation. I mean, it's just simple English. The amount of which, in other words, the words compensation and the amount. And then in subsection 3, it also says the amount of the compensation and the manner of payment and so on. And then one of the criteria, as you said, is market value. Now, our courts have interpreted that to mean the starting point is market value, and then sometimes it might be more, sometimes it might even be less, theoretically. For a lawyer, I don't know about philosophers, but for a lawyer, is it conceivable that you can have expropriation without compensation under this section? I mean, apart from the absurd thing that theoretically you can walk from here to Cairo, but is it conceivable that under this thing as it stands, you can have expropriation without compensation?
If it is, it'll be in exceptional circumstances, truly exceptional circumstances,
Yes.
where various factors render the land worthless, I suppose.
But
You-
that's what I'm
during-
saying. Isn't that possibility so negligible that it doesn't exist really?
Yes, I think so. Well, it may exist every now and again, but
Yeah.
the one example that I heard bandied around was land that was occupied by labor tenants,
Yeah.
and because of that had no commercial value. Perhaps, but I agree that it's the instances where it could arise are few and far between, in my view.
Thank you. Thank you very much. No, I thought so. The second one is an issue that the original question I was going to ask you. As I said, I don't know, as an administrative law practitioner, I don't know if you share this. One gets frustrated. Sometimes there are developments, positive developments in the area, and then you find like one major kind of reversal. And then, you know, so it's developing in a kind of uneven way. And I'm asking this question in relation to something that I found in one of your judgments. I think it was in the Eastern Cape. I had been looking for something to do with the importance of fairness in relation to a hearing, paja or rationality, that kind of, and I think one of your pop crew judgments, I found a gem of a quotation there, which I used unsuccessfully, unfortunately.
Oh dear.
Yeah. but it was probably one of the most frustrating moments of my career, because two courts, including the highest in the land, were not prepared to even give a hearing to a situation where there is unfairness, or at least uncontested unfairness, or perception, not perceptions, uncontested bias. And what my understanding from the development of the law in the Masetla, Albert Law Society cases was that the principle was that something that is administrative action that is unfair can never be rational. In other words, the rationality test almost automatically applies if you can show that there was bias and a lack of hearing and so on. It's a contradiction in terms to say that that can also still be rational. Would you subscribe to that?
Well, I think the problem arises because one is, with executive decision making, one is not dealing with the straight down the line procedural unfairness that we know from administrative law, but something else that developed in the Masetla case and the Albert case. And that is that if rationality demands a hearing, then a hearing is necessary. In the case involving Arms Corps, was it? My understanding of it was that whether the outcome was rational determined ex post facto that there was no need for a hearing, and that may be problematic.
Thank you. Thank you, Chief Justice.
Thank you very much, Commissioner Mpofu. Commissioner Didiza?
Thanks, CJ. I won't follow up the issue because it has been done adequately, but I just wanted to say to the judge, good afternoon.
Good
There
afternoon.
is no legislation as yet, so the matter is still up for debate on the land issue. So
Yes.
your views, and I think that's what Honorable Nyambe was trying to canvass. What are your thoughts about it?
Thank you, Commissioner Didiza. Commissioner Schmidt?
Thank you, Chief Justice. A much easier matter than expropriation without compensation is the issue of one of the earlier candidates today referred to Malede versus Tiroleng. It's a Constitutional Court judgment penned in October. And it refers to Maxan case, which you seem to have penned down as an acting judge in the Supreme Court of Appeal
Yes.
in 2011. In Malede, the appeal room limits the operability of the MPRDA. And you seem to do the same in Maxan for different reasons. Now, it's seemingly, if I'm misunderstood, then please correct me, but if in the instance of Maxan, you were of the view that Lupo, which has now been replaced by Spluma, which was provincial legislation administered by local government, had the right to, well, limited the operability of the MPRDA in the sense that a mining right holder or a mining permit holder may only mine insofar as it is in accordance with the zoning right or the permit, or rather the consent use, as determined by local government. Now, it seems to, the consequence seems to be the same, and maybe I'm missing it, but in the one instance, a zoning right or rezoning of a particular area would be subject to a process determined by the provincial government, and would then, should a mining right applicant then come to mine, it has to fulfill the rights as determined in terms of the MPRDA, as well as the zoning rights. Whilst in the instance where the MPRDA would operate without any limitation, or without any reference to Spluma or Lupo, it would only be subject to the basis of consensus and not to a more considered process in terms of Spluma or Lupo. Now, it's seemingly, and that's a question I'd like to make, seemingly in both these instances, there's a movement towards consent rather than consensus. Maybe I'm reading too much into it. Maybe it was a consideration, maybe not. But that seemingly is the process compared to international law of consent is more applicable in protecting the rights of the land occupier or the landowner. Am I reading too much into it, or am I interpreting it incorrect?
I really am not sure. I mean, I don't know quite how to answer that question. What I will say is that in the Maxan case, it seemed fairly clear to me that the two spheres of government had separate powers that may have run parallel to each other, but both had those powers, and the one couldn't impinge on the other. As a matter of constitutional law, constitutional interpretation. I can't comment on the practical implementation of that. But when I wrote that judgment, my intention wasn't that one trumped the other. They both had their spheres of influence, as it were, and both had to be complied with. And I don't think it necessarily follows that local governments will always be anti-mining. That's approaching it on the basis that we must assume bad faith. I don't think it works that way. But when I wrote the judgment, I was satisfied that that was what the Constitution meant.
Justice Plasket, now that it has been flowing so well, let's round it up by clearing possible impediments which come right at the end, and I think rightly so that they don't interfere with the quality of your interview. When you were here in 2013, it didn't quite flow as well as we both, and by both I mean the Commission and you, would have preferred it to, did it?
No.
I want to afford you the opportunity to clear two things. One, you would recall, according to the record of the proceedings then, there are two issues that flow out. One was an assertion by you that you were being asked questions that are irrelevant or that have got nothing to do with your suitability for appointment, yes, to which some of us took exception. Yes. And two, you could rightly or wrongly have been misunderstood, or understood rather, to be saying that whenever there is a candidate or there are candidates who are white males, even in circumstances where some might have thought transformational imperatives ought to lead us to the conclusion that maybe a vacancy should not be filled, as long as they acquit themselves well, they must be appointed. And you kept referring to the Cape Law, is it Cape Law Society or Cape Bar judgment? It was a protracted interview. I don't want to quote, particularly from page 177 of the transcript all the way through to, I think, at least page 207. And you would recall even your engagement with Minister Hadebe and I. Would you just, in your own words, before I put any questions to you, if any, just explain that or clear that up, if you're so minded?
Yes. On the second issue, with hindsight, I really do accept that I was too dogmatic in many of my answers, and that it was too dogmatic to say that the Commission could never leave a vacancy, despite there being a suitably qualified candidate. It all comes down to the reason for leaving the vacancy. And the example that you cited, I think was a good one, and my answer to that was an inadequate one. Subsequent to the interview, of course, there was the Constitutional Court judgment in Barnard, which dealt with analogous issues, not exactly the same, but the attainment of targets in an equity plan. And there the judgment of the Constitutional Court said precisely that there was nothing irregular in leaving vacancies. So I'm happy to concede that my interpretation of the position was wrong.
And that was rather unfortunate because at the time, you would recall, flowing from public utterances by a former member of this body, the media was all over us, aspects of the media, not all of them, almost seeking to project us as some anti-white male organization, and you could rightly or wrongly have been understood as riding on that wave, and that was the unfortunate part of it.
Well, that was never my intention to ride on that particular wave.
Yes. And the irrelevance.
No, I think Minister Hadebe raised that with me and properly so.
Yes.
And I accept that.
Thank you. You're excused.
Thank you.
Oh, all right. Thank you. Thank you. Thank you so much. You're excused, Judge Plasket.
Thank you very much.
Thank you very much.